Digital Summit. The summit is organized by IAMAI and supported by Ministry of Electronics and Information Technology, Government of India and Niti Aayog. Today, we have with us Shri Dr. Amar Patnaik, Member of Parliament, Rajya Sabha, for a fireside chat on data privacy versus data economy, finding the sweet spot. Welcome, sir. Now, to start the chat, let me welcome Mr. Vivan Sharan, partner Koan Advisory. Over to you, Vivan.
Thank you. Thank you once again to IMAI for doing this and for giving us quite a conceptually rich topic because we can cover a lot of ground. It pretty much defines all debates on internet and digital technologies today. So we have a very wide canvas to paint, and there's nobody better to paint it with from the legislator community than Dr. Patnaik, who's been so involved in these debates. He's been reading, writing, speaking on behalf of his constituents on these issues. So without further ado, Dr. Patnaik, in 2021, India recorded a 352% increase in the number of users whose data was compromised. So this is according to one report, which makes it the third most affected country after the US and Iran. So it makes it accelerating the data protection bill trajectory this year. And over the course of this discussion, therefore, a large part of the discussion can center around the inherent tension, which is also visible in the bill, which is also in the title, between privacy and economic concerns. And IMAI, sir, suggests that we try to find a sweet spot. So what I'll try to do is try to juxtapose, different ends of the spectrum as far as privacy and economic concerns are visible in the PDP or in the data protection bill draft as it stands right now, and the JPC recommendations as well. So I just, to kick us off, sir, this inherent tension is particularly visible between aspects in the JPC report that claim that India should not privilege digital economy over data protection. And again, a lot of people have submitted comments like these to the group over time that, since this whole thing stems from the Puttaswamy judgment and the privacy as a right, and it's a very rights-led framework. At the same time, the GPC and several committees have described data as the new oil. Now, that's of course very commercial in its tone and tenor. So is it possible in your view, at a wider, to start off on a sort of wider question, to actually reconcile this apparent tension, or will it always exist?
Thank you, Vivan, for this, very interesting question, actually. Very, very interesting question indeed. And I have a very different take on this because first I'll speak about broadly about the discussions that took place now that the report has been already laid in the Parliament, and the bill is probably going to come by as well. So the reason why we shifted from personal data protection to data protection bill was not because of this tension, but it was because of this fact that we did not want a turf war to happen later between two different regulators operating completely independently, while it is a known fact that data doesn't travel in only personal data, only non-personal data. It would be mixed packets. In which case, actually, to determine at some point of time if there is a breach, whose authority it is to decide on the breach and the complaint and the offences and all that. So I think I've written about this earlier also, that there is the need for a single regulator. Having said so, we also must be cognizant of the fact that there are several sectoral regulators who are already there and who would probably be there even in future. New sectoral regulators would come up depending on what is the requirement of public policy and governance. So these regulators who are only handling data per se, but could be delving into the arena of the other sectoral regulators, will also have these tension as well. So therefore, we thought that in order to reduce tension, bring them together under one platform. Now to the question as regards privacy and data economy, my personal view is that if you are actually, there is no conflict, there is no tension. In fact, both are complementary to each other. If we are ensuring privacy of the data principal, whose data is basically going to be what we are calling as the new oil, then he should be protected. He should feel confident about sharing his data. if there is an environment or an ecosystem where he feels that his data would be stolen at all points of time, and or it will be taken for one purpose and spent for another and used for some other purpose, if that confidence, that trust, ultimately boils down to a question of trust. So if that is not there, then I think this data or digital economy will not take off. So I think that the sweet spot itself is by having this kind of a legislation, and it should be further, it doesn't end here, it should be further kind of enriched by having smart rules which are much more specific wherever those areas in the act which are unclear, and also having regulations which, besides being smart, should be very dynamic in the sense, because evolving things will be evolving very fast in the technology space, and always regulations lag behind technology. So the data protection authority and the experts sitting over there have to be having these regulations very dynamically and contextually. Contextually, why? Because there are different regulators, different requirements. A health regulator or a health data requirement by a data fiduciary handling health data would be different from someone who is handling, let us say, data relating to supply of PDS, public distribution system. So I have a feeling that my take is that by having both the privacy law following from the Puttaswamy judgment and having a harmonious data regulations by the Data Protection Authority, rules framed by the government, the data economy or the digital economy would actually get a boost. And it will actually, people would be very certain, it will provide a very stable, certain environment for economic activity to take place, including cross-border data flows between countries, between entities, between data fiduciaries. So I think it's a good thing that we are having this thing, and it is not really should not be a source of tension. What we have done in the report, the Joint Parliamentary Committee has evaluated both these aspects, but finally has come out with which will protect privacy as well as give a boost to digital economy.
So, sir, let's drill down from that. So, a privacy respecting information economy is, of course, an ideal where, classes of services are actually competing for with each other over the level of privacy they actually afford to the user. It's an ideal. But let's break down how the data protection bill as it stands today, or as it stood over the last few years, really seems to approach this concern. So what are the instrumentalities? So the number one, of course, is consent. And this has remained the bedrock over the last several years. It's not a new modality. I mean, from the 70s onwards, in US Public Health Administration, consent first appeared as a instrumentality to ensure privacy. But is it an appropriate one to reconcile the tension that we speak of between privacy and economy? Because there may be, for instance, a disincentive to data minimization if you have consent as the bedrock. And I'll just explain that for one more second, which is that I, as an operator, I always put on a sort of market lens when I look at these policies, would want to maximize the amount of data I collect, or to have a sort of a maximal approach to the consent that I take, because I don't want to keep taking it because it engenders a certain friction. So do you see a certain tension there between consent and the principle of data minimization?
Yeah, you're partly true, but the point is, it is not just data minimization that the data fiduciary has to take care of. He has to also take care of purpose limitation. He has to also take care of storage limitation, collection limitation. So all these principles has already been laid down in the Puttaswamy judgment, proportionality. Right. Many things are laid down. So once the principles have been laid down, the rules that are framed could be deficient at some point of time, and they need to be either elaborated in the rules or the regulations. But per se, I think my about this quite a bit, that suppose you take consent and still the data is used for various purposes in which it causes harm directly or indirectly to the data principle. What happens? So a harm model would have been better in the sense it would have shifted the burden of maintaining the privacy of the data principal completely to the data fiduciary, while at the same time giving some kind of easy endpoint for data from the data principals. The point in current system, which is also there here, and as you said, it's all because it's easy. It builds trust, it gives confidence to the data principal, but it does protect you completely against all possible risks or risks of harm. Therefore, I think we can't say that the consent-based framework is the best and that will minimize this tension. But what it does definitely is that it builds this trust, and very directly it builds this trust, and therefore it would improve the environment. In which case, the data, the entire sphere of informational privacy and digital economy would flourish. Having said so, I do admit that getting consent, the way it has been described, the way it has been mentioned in the bill, may be very cost heavy at the initial stage, and therefore a much more better structure or architecture would have been harmed.
Sir, that is a very
To
important.
be
So that's a very important inflection point. I'd like to dwell on that a little bit. You've actually probably created a little bit of news by saying this, but the point is, how did it come to pass? In your discussions and deliberations among the group, was this issue raised on how has consent become the bedrock of what we're talking about? Why was the harm-based or specific harm-based approach discussed, or was it a sort of the trajectory was locked in, so one had to build on what was already a base draft? Is it a function of state capacity around the design of public policies like this or of laws? Where you can't reopen something fully, and it's impractical, or was there some other sense that consent should trump all other modalities of ensuring privacy?
Yeah, you see, when the point is the entire discourse on having a law and discussion on having a law quickly on data protection started with the Puttaswamy judgment after the Supreme Court recognized that it is a part of our fundamental duties, fundamental rights. Now, the point is the Puttaswamy judgment itself, if you go through it's a thick judgment, if you go through the entire judgment, you would see that the Supreme Court itself has relied heavily on the UGDPR. And even the BN Sri Krishna Committee report has relied on the UGDPR. UGDPR is completely consent-based. And there is a tendency in what we call in public policy as mimesis. That means you mimic what somebody else has done, because our isomorphic kind of an architecture that you set up, because institutionally it's easier to defend. Number one. And number two, it will also help you in cross-border data flow, because the other geography is already having a similar structure, a similar ecosystem. Right. So they can easily evaluate it. And that is why I think we have followed. I'm sure over a period of time, people will graduate into a newer regime.
So, sir, on the issue of cross-border data flows, again, something where privacy and I guess commercial concerns collide fairly directly. Do you think that the requirement for the Data Protection Authority to consult with the central government before any transfer of sensitive personal data, along with the introduction of new grounds such as public policy and state policy for refusal of this transfer, can introduce a friction in cross-border data flows that may be irreconcilable with the framework that we have on hand?
Yes, I know in my dissent note, I've mentioned this, that the right of the citizen or the data principal to have his informational privacy is guaranteed now by the Constitution, because it's a part of the fundamental rights. The Supreme Court has interpreted it. So it is not the job of the government as if it is giving this right to the citizens. The government itself is one of the data fiduciaries and the largest data fiduciary. So I think the role of the central government in this entire ecosystem should have been as less as possible, should have been minimum. And the things should have been given to a much more independent data protection authority. I have mentioned this, many others have mentioned this as well. The only point in favor of having a similar, having this particular clause in the section of DPA in the suggested DPA 2021 is the fact that because different contexts and different sectors would require different would require treatment of data as sensitive, because it depends on the use of the data. So whether it is sensitive or whether it is not going to be sensitive, and therefore I think this context and this requirement use case has been left to the central government to decide and therefore prescribe. I have a feeling that these would involve, things relating to, again, security of the country, sovereignty of the country, interest of other things. Let's say like a pandemic situation, dealing with the pandemic, even though it has been separately mentioned in the another section is there on health itself, where non-consensual processing is possible. But I think this should be much more specific in the rules when they get framed. When was that objected to this because this is very vague, no state and policy. And as I said, overarching theme in this entire bill has been as if it is the central government which is giving this right to the people consequent upon the Supreme Court saying so. It is not so. It is coming from the Constitution, flowing from the Constitution. And the central government itself is one of the data fiduciaries who has to respect the citizens' or data principles' interest and privacy. And that is why I think their role should have been from arm's length as minimum as possible. Hopefully, if an independent DPA gets into motion and gets into action, these friction areas should decrease. Otherwise, yes, it could be a friction area, because what the regulator or what the public policy enthusiast would interpret as a requirement not to allow cross-border data flow, a commercial interpretation who is much more knowledgeable as far as technology is concerned might actually see business in it, and business in it not just for himself, for the country as a whole. So these are the things which will have to be sorted out by the DPA over a period of time.
So, relatedly, you know, uh, in a much wider frame, geopolitics is becoming increasingly important for what we call digital trade or even technology supply chains more broadly, and trade and investment more generally as well. So, this is a more general question. So, if you allow me, a lot of regulators will have to grapple with the geopolitics of technology, but they're not actually equipped to, in a sense. You see this across standards domains most prominently, where standard setting does have a political end at on many occasions, and you're seeing this in telecom and other critical infrastructure also. The importance of allying with, or if not allying with, at least seeing eye to eye with democratic nations, keeping technologies as free and fair as the state and the nation, that is employing these also. So, how does and data is the most contentious of all possibly realms of regulation. You've seen the Japanese. In fact, I was interested to see that they also submitted some recommendations to the committee, which were noted at least on the document that was made public, that the Japanese have also submitted some. And I assume that their construct in G20 around data free flow with trust and so on are things that they are trying to push India to adopt. But just coming back to the question, sir, that how do we equip our regulators to be 21st century ready? Because these concerns are playing out everywhere. You're seeing it on a day-to-day basis with, say, the kind of components you need in your smartphones. So it'll affect everyone. It is definitely a state policy consideration and a public interest one. But regulators have very narrow charters and mandates: orderly market growth, consumer protection. So, is there therefore a sense that you get that we will actually allow the state to creep back in to domains of regulation, erstwhile domains of pure play regulation, because of this necessity? And another tension, if you will.
See, I have separately said or probably tweeted that data ultimately, when we say that it's going to be the new oil or this, it will going to become a trade item. So a trade item means you will be allowing the cross-border data flow to happen between countries and between different geographies. You may have geographies which are not politically aligned with your country, but then you may still want trade and commerce to flourish or trade and commerce to go on. In similar kind of situations, and then there could be, as you know, as you said very correctly, the standards of anonymization or standards of various standards which have to be codes of practices which have to be done by the data protection authorities in different geographies may be different, and that could actually put in conditions just like the WTO trade. So I have always separately said that I think the day is not far when we will need to have another international organization which will be managing these data flows between various countries, and it will address some of these issues. Some of those issues be trade, it must be prohibiting free trade, just as it is there in WTO. So such things should be avoided by having artificial standards which are very difficult to comply because of someone having some technology which the others do not have. So I have a feeling, Ivan, that after getting discussed in G7 and G20s, it will eventually transform itself into a world body which will be looking at these issues. Only one state getting into the regime because of protecting its own interest against another geography going beyond the data would happen if these bodies are not there for dispute resolution, for grievance resolution, for effective enforcement of free cross-border data flow. And that is why I think in the EU GDPR also it is said that for cross-border data flow, they would assess the other country's data protection regime as to whether it is necessary, adequate, and sufficient or not. So eventually, when you start having with all the countries in the world, it can't happen. It has to be a global.
But sir, will it indeed be all the countries in the world, or do you see a sort of a splinterization of international frameworks? I mean, you already see it in some areas, the Budapest Convention and others, where even India has not sort of signed on because we were not part of it. You may see similar refusals to sign on to constructs, particularly by larger emerging nations or developed ones, if they're not part of the foundational sort of construct. And then to find the lowest common denominator among countries with very different governance styles may be a very difficult proposition in the future.
Very true. Very true. Very true. I agree. And even just beyond the political geography of things, political economy of things, the aspect would be also purely commercial in the sense that I foresee that because of data localization requirements, if the policy is designed in such a manner that India can become or can provide the lowest data storage cost world, then some of those people who are storing data in other countries may actually shift to India. Now, if that happens, the developed countries will also resent such kind of a situation.
Absolutely.
But it gives us the greatest opportunity to do so. But then it's a tall order, as you know. It's a very tall order.
So, sir, on this question of localization, you've written about it, and I'll quote you. If there are several areas where, again, this is to bring out the tension where digital economy and data protection, sort of the tensions play out most prominently. For instance, you have written that with regard to data localization, a measure meant to protect user privacy, that as many as 60 different permits are needed to establish data centers in India today, which span 15 government departments. So clearly, you yourself, sir, regard ease of doing business in the digital brackets infrastructure economy as key to an effective data protection ecosystem. So here you actually see the commercial imperative in data protection as being central to ensuring the privacy of individuals, right? So it's impossible in this sense on the data localization front to decouple digital commerce or digital infrastructure from and incentives thereof from the privacy of individuals. Similarly, the JPC has also written that data localization is going to create employment and jobs and investments and so on and so forth. So, would you care to sort of comment on whether you see, India actually moving towards becoming a sort of data localization or data hub, and the impediments that are there to do so. And I have a follow-up question to this once you give us your view.
Right. So, in fact, in that article, I had mentioned very clearly that the way to data localization, enforcing data localization, is not by coercion, but by incentivization. I followed that. I've written that. That by having this in the law and having it in an enactment is not going to result in data localization, because it is our only domestic companies or domestic firms who are taking advantage of low costs outside will be deprived of getting that service. And whether it is possible to have when people are storing data in clouds and in internet, is it possible to have strict data localization? Therefore, I've written all that you mentioned about 60 licenses and 15 departments. In fact, I mentioned in that article too that there are, electricity supply, uninterrupted quality electricity supply is not available in many places. So how do you have a data center there?
Yeah.
So the idea of public policy should be now that if you want to have data localization, you incentivize people to set up data centers by all these things, making things easy, not taking so many licenses. And I think the government is moving in that direction. If you look at the budget speech of finance minister, I think last year, she has talked about incentivizing it.
Yes.
Incentivizing in terms of tax benefits, tax rebates, loans is one thing, but
Yes.
actually the field, making it easier to set up your centers by removing this license raj, ensuring electricity supply, ensuring there are no labor problems, ensuring that there are no land problems. I think that is more important, and that is where the states will also have to play a significant role. So my take is incentivize. You can't really coerce it.
So let me play devil's advocate on the question of data localization being a competitive lever, as the bill perhaps sees it, and perhaps the committee too. Do you actually think that India should create legal regulatory frameworks that nudge market participants to compete with the globe on the infrastructure layer, or do you think that we're better suited to fighting it out in the applications layer? So just to be clear, I mean, if we want to do the former, we need to know where the value of hardware will initially be going, right? So we don't even make data center racks today in India. We have to import the very basic non-computing components to create these centers. And then data centers have become more or less a utility service, fairly consolidated market, and so on and so forth. Whereas the application layer is somewhere where you see so much competition, so many Indian firms, so many now unicorns and investments that have gone. Isn't it more logical, therefore, to focus on the momentum that has been generated in the applications layer rather than lament about the lack of essential infrastructure that is localized in nature? Because even that localization, the value may not be fully captured here, and the longer term implication. So this is where the tension between, I guess, securing that infrastructure and the economic competitiveness concern comes in.
Yeah, got it. Got the question. But the point is, by having this piece of legislation in place relating to localization in the Data Protection Bill or Data Protection Act eventually, at no stage it is going to actually deter people who are developing applications and developing applications for use around the globe using services of data from both inside and outside the country. But having realized the fact that the startup ecosystem will get a hit if they keep on waiting for this infrastructure to come up and then start using it. So a carve, I think, has been suggested. If not mentioned in the report, you will find it in the bill, that a carve out has been given for the startups and MSMEs, where they will be given, they will not be made to suffer the initial compliance cost. And so
Right.
be able to take care of it. But at the same time, it will actually, we have to make concerted effort to make India the data capital of the world, at least in terms of data storage. We have
Right.
the potential.
So related to startups is a trend we see in the context of GDPR, which very, to cut a long story short, there's been a lot of litigation in the EU. And a lot of this follows from the enforcement of rights-based data protection frameworks. And in India too, under the current framework, businesses are liable to compensate individuals for the losses caused by negligent handling of their sensitive personal data and so on. Does this, open up a new area of litigation? Also, there is in clause 64. There is greater litigation exposure, I guess, because it provides for class action suits. And you've seen in the case of the NCLT, sir, I mean, where, with residential buildings and towers and so on, that 2-3 people get aggrieved and, they form a group and go and stop construction and so on and so forth. It becomes very complex very quickly. So is this, how do our startups navigate this environment? So it's getting increasingly complex for a lot of players. And connected to this question is, startups may also need to rely increasingly on intermediaries like consent managers. I mean, you already see it in the digital payments ecosystem. You no longer can plug and play so easily with your service providers, particularly if you want to offer a bouquet of services that respond to, say, RBI regulations on a dynamic basis and without disruption. You have to rely on a fintech provider or a payment aggregator to sort of solve for some of the issues that come up through regulation. As a general philosophy of how we should proceed as a state on some of these areas where there are smaller businesses that get implicated in the crosshairs of regulation that may be warranted, but may not be fully accounting for these kinds of externalities, how do you suggest we proceed, sir?
See, there is no doubt that new jurisprudence relating to data privacy, localization, cross-border data flows, government, some the DPA allowing it, DPA not allowing it, some people treating this as a sensitive personal data, some people not treating it as a sensitive personal data. This came up quite adequately during the depositions also before the committee. People very differing views on this. But somewhere one had to take a stand, and we have taken the stand and given this report. But these issues will eventually come up, and a new data jurisprudence will develop, I'm sure, in the country. But as far as the startups is concerned, and as far as the micro small sector MSMEs are concerned, the committee was very cognizant, all the members were very cognizant of their requirements, of their problems, and therefore prescribe what for the sandboxes, the regulatory sandboxes. The RBI has regulatory sandboxes. The SEBI now has regulatory as well as innovation sandboxes. So I think we can, the startups and the MSMEs will not face any problem. But having said so, if there are problems, then the policy and the DPA and everybody has to step in, because they are providing value, unlocking value in using this data, and that's for the benefit of society. We have to insulate them against legislate, this kind of various actions. And it has happened, as you said, the home buyers. Home buyers, only one person could actually go and install the entire project. So a vote was made subsequently. The amendment has come in the IBC. In fact, being a member of the finance committee, we did debate that particular aspect, that there is no ticket size, nothing is mentioned, dissent notes are also given. So this will evolve, I'm sure. But the ground, the foundation of the law should be that the MSMEs and the startup, that environment, that particular sector should grow as they are growing currently, and even better.
So, dissent notes reminds me that your dissent note was perhaps exceptional. It argued for a federalized data protection structure. And related to that question, sir, is the contrary view, perhaps, and perhaps there's no absolute truth, but that for digital governance, a certain degree of centralization is inevitable because you want to provide a common minimum standard of infrastructure and services to a national market. to maximize efficiency and the promise of digital itself. So, how do you reconcile that with your suggestion around around states having more of a say in data protection? And where are you coming from when you suggest that?
Okay. Number one, I think the entire data protection regime that we are going to have in place, we are thinking of discussing everything is flows down from the Pottaswamy judgment. The Pottaswamy judgment has laid down the basic principles of what the law should be, how the interpretation. The principles have been well laid out. Now, all rules, all act provisions, all regulations has to be in line with that. Otherwise, it will eventually be struck down by the Supreme Court. Having said so, therefore, I think there is no confusion as regards the principles, and
Right.
they are applicable to the entire geography of India, states as well as the central government. My suggestion for having a state-level data protection authority came from the idea that the point is not really you know fostering a digital economy. It came from the point of view that if there is a data breach, if there is a complaint, and if there is a complaint against a collector of a particular district by a citizen who says that his data has been breached and a harm has been caused to you, then the Data Protection Authority cannot even by any stretch of imagination be able to decide on that particular thing. And even if he does, uh, there could be bias attributed to him because of different political parties governing in the center and the states. And this is not really at the collector's level, it could be at the Chief Minister's office as well. And therefore, this complaint handling, because the penalties are stiff. There is Section 8, is a criminal offense. So I don't think it is going to deter the growth of economy, the principles that have already been enunciated by the Supreme Court. What it is going to do, however, is to build this trust between various stakeholders. The state governments are also very important partners. And this not having the state data protection authorities will create this tension, one. And number two, the central authority will be overwhelmed because there is some particular person in some remote village in Malkangiri wanting to make a complaint and where there is no internet services. How does it do it? So that is why I have suggested that, and much in line with the Right to Information Act, the RTI, again, the principles have been laid down by the court. The act has been passed in the parliament, but the separate states have separate jurisdictions. And in this case, it is much more important because there are state laws which have been passed in the state legislature which generates data within the state specific to that state only. Why should a central government be discussing about state land laws or Gunda Act or some other act which has been passed in one particular state may not be there in other state? The context will not be known to them. And the Consumer Protection Act, also, if you look at that, it has gone down to districts. What is it is doing? It is basically trying to protect the consumer. Consumer is one particular citizen. Multinationals, everybody who supplies goods and e-commerce platforms, everybody, but the structure is the same. Here also, the data flow, the intermediaries, the big tech companies, they might be involved, but the involvement of the penal provisions for ensuring protection kicks in when a complaint is generated. And that particular stage, to have one monolithic organization sorting out all these issues, I think is not going to be operationally feasible, not going to build trust between the state and the center, and more importantly, might cause harm actually to the data principle. Imagine again, let me supplement the last point, a public order situation arising in some place in, let's say, Wayanad, and then the SP has to take an immediate decision as to use this data of whatever he has to contain the situation. Currently, it has to take permission from the Central Data Protection Authority. Not possible.
Yeah. So this has been a wide-ranging, discursive, yet deep discussion. I think we all expected that from you. So thank you very much. Just like is happening around the world with the Elizabeth Warrens of the world, bringing technology from the periphery to the center of political discourse. There are several, enlightened leaders like you who are doing the same in India, and we are thankful because obviously societal, technological concerns around modernity, around economy, are all sort of defining us as a democracy. And so thank you very much for participating in these debates, and thank you, IMI, for enabling it.
Thank you so much. Thank you so much.
Thank you, sir. Thank you so much for such a wonderful conversation and insights. Thank you to all the delegates for joining India Digital Summit. Stay tuned for a lot more.
Thank
Thank
you.
you once
Bye-bye.
again. Thank you to IMI and thank